proceed with your argument. Are there any announcements? Hearing none, please call the first case.
American Business Supply Incorporated et al. Versus Tennessee State Board of Equalization.
Good afternoon.
Good afternoon. May it please the court, my name is Drew Raines with Evans Petrie in Memphis. I'm here today on behalf of the taxpayers. I would like to reserve 3 minutes for rebuttal, if that's all right.
3 minutes, yes, sir.
This case is about finding the boundaries of discretion for administrative agencies, specifically the State Board of Equalization. In this case, it's not an issue of the agency overreaching the bounds of the statute that created it, but a failure to meet the minimum statutory duties. The statutory duty up here on the board is 67.5.1606A. Based upon the appraisal ratio studies and other pertinent information, the State Board of Equalization shall annually determine the overall ratio of appraisal for each property, for property in each county of the state. These agencies have broad discretion, but that discretion is intended to serve the purpose for which the agency was created. Here is what happened. The board certified an equalization ratio of 100% in Shelby County for tax year 2018. The taxpayers challenged that ratio and it was assigned to an administrative judge. There was a hearing and evidence was taken. The judge evaluated the evidence with specialized agency knowledge. That evidence was a sales ratio study performed by Dr. Sunderman of the University of Memphis that concluded a 94.4% ratio. The administrative judge found there was nothing in the record to show that that evidence was flawed in any way and that it proved that the 100% ratio failed to achieve equalization. No evidence was presented counter to the taxpayers' evidence. There was nothing else for the judge to weigh. But the administrative judge ruled that the purpose of the hearing was to determine whether or not he had to determine the ratio. And that is wrong. The board cannot accept the evidence and ignore it in favor of, well, this is how we've always done it. That is not good enough for the taxpayers. The State Board of Equalization is using its power to avoid equalization, not to achieve it. The chancellor below erred by following the administrative judge's flawed reasoning. The chancellor said the board did not violate their statutory duty to equalize because the procedure in adopting the ratio was valid, regardless of the fact that the ratio was incorrect. No, the State Board of Equalization violated the statutes by which it was created. It failed to meet the most basic requirement of equalization. It's the State Board of Equalization. It cannot turn a blind eye to its failure to equalize. The chancellor is putting form over substance. He's putting procedure over equalization. Equalization was not achieved, in fact, for the taxpayers in Shelby County in 2018. Adopting an incorrect ratio in a procedurally valid way does not cure that problem. The chancellor said that the board's decision was based on substantial and material evidence. No, it wasn't. It was not. It was made based on a faulty presumption that was rebutted by substantial and material evidence. So what we're asking this court to do is to reverse the chancellor and hold the State Board accountable to fulfill its statutory duty to equalize. Do not let them make an arbitrary and capricious decision and hide behind the curtain of unlimited agency discretion. That is not appropriate. The taxpayers here are harmed because without equalization relief, they are being taxed on a different basis than real property taxpayers. So
let me ask you, if I understand the statutory concept, the agency is supposed to do an appraisal ratio study once every 2 years, but an appropriate appraisal, determine the appropriate appraisal ratio each year. Which of these, if not both, do you contend the agency has failed to do?
Your Honor, that's a good question. There are actually two different government entities involved. The first government entity, the State Board of Equalization, has the annual duty to determine an overall ratio for the county. The other entity is the Comptroller's Division of Property Assessments. That is not the State Board of Equalization. It's a different entity that has a different duty. The State Board is looking at those two duties together, and they're coming up with a presumption. They're saying, well, we have to determine every year, but we rely on the division sales ratio studies in making our determination. And so if the division only has to perform a sales ratio study every other year, then we must be able to rely on the most recent information available to us, which is the prior year's study, if the division did not perform a study for that year. And so what they're doing for 2018 is looking at a ratio study for 2017, which was a reappraisal year, and so the study would presumably come up with 100%. But it's flawed in two ways. First, there was no sales ratio study performed for 2017. Shelby County did reappraise, but the Division of Property Assessments did not check the accuracy of that reappraisal by doing a sales ratio study, which they were required to do by statute. So the State Board not only isn't annually determining a ratio, but they're relying on an agency that didn't perform their statutory duty and perform a sales ratio study for 2017.
So part of your contention is that the every 4-year reappraisal study in Memphis or Shelby County does not satisfy the reappraisal or the ratio study. Is that what you're saying?
The reappraisal is different than a ratio study. That is correct.
Okay, all right.
Let me ask you, in the findings of fact by the administrative law judge, the report states that in 2017, the division conducted a statistical analysis. How is that different from a study?
That is a good question, because the division never revealed a statistical analysis. That's not in the record. The court relied on this fact without it being established, and that is an error on the part of the chancellor. There was no...
It is in the judge's findings, the administrative law judge's finding, with the trial court relied on. Is that right?
Right. The administrative judge, the Board of Equalization, the chancellor, everyone is relying on the idea that there is something substantive backing up the presumption of 100%. There isn't anything in the record to show that any kind of analysis was done. When we appeared at the State Board's meeting in April of 2018, the Division of Property Assessments was there. We raised our hand and we said, we believe that the ratio is wrong, but because the board sets the meeting so early, it's literally impossible for us to provide evidence that would prove anything. And so we're asking that it be assigned out to an administrative judge. Now, the division at that meeting said, we don't have an opinion on the 2018 ratio. We haven't done any analysis. That was the evidence from the hearing at the time that the board adopted the ratio of 100%. There is nothing, no evidence backing up that 100%. So there are a couple of reasons that the board is refusing to correct this ratio. First is that presumption that's created by the statute. They're interpreting a presumption that they can rely on a 100% ratio in the second year. But another issue is these procedural roadblocks. As I said, the board is setting up these meetings to adopt ratios before any information is available to the public to be able to review those proposed ratios. And so the administrative judge, the chancellor, part of their reasoning was based on a criticism of the taxpayers' timing in submitting evidence to the board. They're saying, you submitted it too late. You should have submitted your information at the time that we made the decision. But that's literally impossible. The board is making these decisions. They're adopting these ratios in mid-April. The values, which are a critical part of that analysis, are not even released until after that. And The sales data that the taxpayers have to get from the assessors is available by April 1st, which is not a very long time for them to get the information and to analyze it, but it is possible. But the values are literally not available at all until after the board's meeting. There's no reason for the board to meet in April. The board's own rules allow them to meet as late as July 1st to adopt these ratios. And so by moving the date up for reviewing these ratios, they prevent taxpayers from being able to have the information needed to show the board that their ratios are not correct. Now, if the board wants to rely on a presumption that 100% is correct in the absence of any other information, maybe that's appropriate. But where the taxpayer has submitted proof that the administrative judge assigned to the case essentially says this is flawless evidence, this proves that the ratio is wrong, why can the board not correct that ratio? That doesn't make any sense. The board is supposed to use all of its power given to it by the statute to achieve substantive equalization, not to adopt, not to rubber stamp a ratio that's handed to them on a piece of paper. That is not how it works. What should the state board be doing? They should be doing everything in their power to effect equalization, not using their power to avoid inconvenience. The statutory scheme as a whole pushes the board to do what it can to achieve equalization. Under TCA 4.3.5103, the State Board of Equalization has the following duties and functions: to, number 2, effect the assessment of all property in the state in accordance with the Constitution of Tennessee and all statutory provisions. The State Board shall exercise powers conferred upon it by law to the end that assessments in every taxing jurisdiction may be in accordance with the law. They are to use all of the power that's given to them to achieve equalization. The board should be considering challenges to ratios instead of using their discretion to turn a blind eye, to look the other way. They are adopting bad ratios, and they are not allowing taxpayers the opportunity to challenge those ratios. It's like an assessor valuing a property. If the assessor values your house in a procedurally valid manner, that value is not necessarily correct, and it should be corrected if it's incorrect. The same is true for the ratio. The ratio affects the taxes that you pay, and it should be challengeable. So, wrapping up, what are we asking this court to do? We're asking you either to determine the 2018 ratio based on all of the evidence that's in the record. There is no evidence of a 100% ratio. Or to remand the issue to the State Board of Equalization to determine a ratio. If the State Board decides to hand the issue off to the Division of Property Assessments to do a sales ratio study, the sales ratio study is going to come up at 94.4%. There is only one right answer. Thank you for your time.
Let me ask you, you said there's only one right answer.
Yes, sir.
Doesn't it depend on the sampling of properties used to determine that ratio? If someone use a different set of properties, may that ratio be different than the 94 that your expert testified about?
That's a good question, and that's why we were careful to make sure that Dr. Sunderman performed the ratio study correctly. The sales that are used in a sales ratio study are the qualified sales, the sales that the assessor, or in small counties, the division, review, and they qualify as being appropriate sales to be included in the sales ratio studies. That's why we have to wait on that information from the assessor, because until they release those sales qualifications, we don't know what sales can be used in the sales ratio study.
Okay.
All right, thank you, Mr. Raines. We'll hear from you on rebuttal.
Thank you.
Good afternoon.
Hello, my name is Joseph Longenecker, and may it please the court, rather. My name is Joseph Longenecker, and I'm representing the State Board of Equalization in this matter. This case is somewhat odd, because as it's been presented thus far, it sounds like this is a challenge to a decision by the State Board of Equalization to set an appraisal ratio. But that's not the procedural posture of this matter. This is a challenge to a declaratory order that was assessing the validity of the State Board's earlier decision. At the 2018 meeting that's been discussed, the State Board of Equalization set an appraisal ratio. At that time, the petitioners in this matter were not involved. As far as I could tell, the petition that was filed by counsel was filed on behalf of the taxpayers of Shelby County generically. And they raised the issues that they presented. They presented some evidence that indicated that the ratio was perhaps different. The State Board had the previous year's reappraisal. It looked at it heard the evidence. It had these, rather to be specific, it had the Division of Property Assessments that said, we're following our normal course of procedure. We have a previous year reappraisal. We're going to carry that number over into this year. They also heard the evidence presented by petitioners, now counsel. They voted and they determined to follow their normal course of proceedings. That was concluded. There was no, and then what has been raised now is a declaratory order proceeding, which is saying, was this valid? And that's the question that is presented to this court today. And much of the procedure in this case at the administrative law level, and even to some extent at Chancery Court, has been an attempt to relitigate the original question. What was the appraisal ratio? That's not the question that was before the administrative law judge. That's not the question that was before the Chancery Court, and it's not the question that's before this court. The question is about the validity of the order. And as a review of the validity of an order, it is evaluated under the standard of review in TCA 45322H, and therefore, as long as the order is supported by substantial material evidence consistent with statutory and constitutional provisions, and not arbitrary or capricious, it is valid. The underlying statutory framework here is the setting of appraisal ratios, which are used as relevant here to equalize between tangible personal property, which is commercial tangible personal property to be specific, which is reappraised annually, and real property, which is reappraised on either a 4, 5, or 6 year cycle. Because due to the fact that values change over time, there's naturally some drift between the real property values and the tangible personal property values due to the different timings of the reassessments. The setting of appraisal ratios is the way that the State Board of Equalization endeavors to manage these problems. For reasons of efficiency, we don't require real property to be reappraised every year. But for reasons of fairness to owners of commercial tangible personal property, we use the appraisal ratios as a way to bridge between those two issues. The statutes, however, vest significant discretion in how the appraisal ratios are determined and how the appraisal ratio studies which are used for those determinations are conducted. The board has in 1604A discretion over the timing and manner in which appraisal ratio studies are handled. And then in 1606A, it's supposed to use any appraisal ratio studies and any other pertinent information to determine what an appropriate appraisal ratio is for each county annually.
And what would that other pertinent information be?
As relevant here, it would be obviously the taxpayers showing up and saying, we have this additional evidence for you to consider would be one instance. It could also be if there was other information on the record that the State Board was aware of. It seemed the statute is unclear about the scope. It seems like it's just whatever information the board has that seems relevant. So in this matter,
Well, what evidence was before the board for the board to make its decision of 1% or?
a 100% ratio, Your Honor, which then
100%.
means that there would be no adjustment, there would be no reduction in the value of the tangible personal property, no reduction in the assessed value of the tangible personal property, and therefore resulting in
But
increased
aside from what the taxpayers brought forward, what evidence was before the determining body to make that decision?
The evidence before the determining body, Your Honor, would have been the fact that there had been a full countywide reappraisal in 2017, and then the tax evidence presented by the taxpayers.
Was there a study in 2017?
The record is not clear on that, frankly, Your Honor. There's some indication that there was a statistical analysis conducted, but I haven't seen evidence either way on how rigorous that was or how extensive that was. There's no evidence in the record
Isn't
either
that
way.
the taxpayer's argument? And to play on an old commercial by Wendy's, where's the beef? Here, where's the evidence? when you say it's not clear, that tells me we don't know what evidence they made their decision.
I think it is, the evidence that was relied on is clear, Your Honor. Whether there was the nature of the statistical analysis conducted is what's not clear. What the State Board of Equalization is relying on is that the county had gone and done a full reappraisal. They had gone and reworked all of the values. And as the State Board mentioned, as a State Board member rather, mentioned in passing, the assumption is there isn't going to be that much change from year to year and therefore they stuck with the previous year's, the comprehensive work that had been done on the previous year. And as has already been mentioned, the statutory scheme assumes you can use previous year's information for making these kinds of determinations. The statute only, by default, requires an appraisal ratio study to be conducted every other year. Presumably, then, you can rely on information from a previous year in making a determination of the appraisal ratio.
Was there a study in 2016?
I believe, I don't think there's any, I don't know if there's anything in the record on that, Your Honor. I believe plaintiffs have indicated that a study was done in 2015, but I don't believe the record shows anything either way on that.
But the statutory scheme requires the division to conduct a study every 2 years. Is that right?
It requires the division to conduct a study every 2 years unless the board determines otherwise, Your Honor.
Okay.
16, and the way the statutory framework fits together is 1604A grants the State Board of Equalization, they get to choose when and how appraisal ratio studies are conducted. The Division of Property Assessment shall conduct appraisal ratio studies in all counties of the state in such manner and at such time as shall be determined by the State Board of Equalization. The requirement in 1605B1 is that in order to assist the board in its determination, the Division of Property Assessments shall conduct appraisal ratio studies in all counties of the state at least every 2 years, unless otherwise determined by the board. The board, in the statutory scheme itself, is granted discretion over when an appraisal ratio study needs to be conducted. And the longstanding practice of the board, as was testified to at the hearing, is that when there's been a reappraisal, they use that. They treat that as being functionally equivalent for an appraisal ratio study. They don't see a reason to repeat the work done via an appraisal rate. They view the appraisal ratio study as being redundant, and therefore they don't do it when there's been a reappraisal.
Let me make sure about your argument about this analysis that was conducted in 2017. It's not your argument that this is a study that complied with the statute.
Frankly, Your Honor, there's not enough in the record on that to determine one way or the other. It might have, but the study whatever statistical analysis was conducted wasn't in the record. Our argument is just that the board has discretion. So what we have to argue, given the record that's in front of this court, is that the reappraisal is at the very least other pertinent information, and that the board has discretion to determine that it could rely on that information, and that an additional appraisal ratio study would be unnecessary and duplicative, and that's our contention.
All right, so you're not calling it a study, but you say it was an analysis.
Yes, or at the very least it's other pertinent information, Your Honor. It might have qualified as a study, but due to the rest of 1605B lays out rather specific requirements for what counts as an appraisal ratio study, and I'm hesitant without actually seeing the statistical analysis to argue that it would definitely qualify under that. So, as has been alluded to extensively, the State Board, in its longstanding practice, has treated countywide reappraisals as functionally equivalent to an appraisal ratio study and hasn't required the redundant appraisal ratio studies, and therefore has viewed requiring an additional appraisal ratio study as redundant in both the year of reappraisal and the year afterwards. Therefore, since there had been a countywide reappraisal in Shelby County for 2017, it followed its usual practice. It said, we have a recent countywide reappraisal. We'll also look at the additional pertinent evidence presented by the taxpayers. It weighed the evidence, and it chose to go with the fact that there had been a complete reappraisal in 2017. This is a normal exercise of fact-finding and weighing the evidence committed to an administrative body by law. This is not the sort of thing which would render a decision invalid. even if perhaps the evidence could have been weighed otherwise. The petitioner's arguments have focused on a few different points throughout this case. They've argued that the new evidence that was presented by Dr. Sunderman in the ALJ proceeding should require a different result. They've argued that the board didn't make a determination because it adopted one piece of evidence and discarded another. They've argued, at least on reply and in this court, that the failure to conduct an appraisal ratio study every 2 years necessarily invalidates the appraisal ratio that was set. None of these arguments have merit. A decision can't be arbitrary or capricious because it didn't consider evidence that wasn't in front of the body and, in fact, wasn't produced. Plaintiffs have alleged that there were timing issues. Frankly, that wasn't raised in their arguments below. If there was an argument that it was arbitrary and capricious because of the timing chosen by the State Board of Equalization or that this infects the validity, that should have been presented to the administrative law judge as an argument. They chose to present, instead, focused most of their argument, as far as I can ascertain, on this new study they were presenting, which isn't relevant given the procedural posture of this case. The board determines, the fact that the board adopted one piece of information rather than another is a determination. If this court decided to adopt a lower court's decision in full, which has happened from time to time, that does not make what this board is doing not a determination. It's still a decision. It's just a decision that something was completely correct. That sort of decision is not invalid, even if, again, one could choose otherwise. And finally, as they've discussed, they've raised this issue of the 2-year assessment, of the 2-year appraisal ratio study requirement, which they've treated as mandatory. As has already been explained, the State Board has discretion over when and where these are conducted. The default requirement is binding on the Division of Property Assessments, not if the State Board has freedom to waive it. And here, the State Board still followed the basic intuition of the legislature behind putting this rule in place. The State Board does require there to be some sort of comprehensive treatment of the county's property before it makes a decision within the last 2 years. The only decision the board has made is that a reappraisal is functionally equivalent to an appraisal ratio study. This is within their discretion, and at the very least, it is not the sort of thing that could render the board's decision invalid. And if there's nothing else, I would cede the rest of my time, Your Honor.
Thank you, Mr. Longnecker.
Thank you very much, Your Honors.
Mr. Raines, we'll hear your rebuttal.
Thank you, Your Honor. The State Board's attorney points out the procedural posture of the case. The State Board agreed that the petition was the way to substantively challenge the ratio, so I don't know why that's an issue now. Was the ratio valid? The administrative judge said that procedurally, yes, the ratio is valid, and so therefore the question is over. No, the question is not over. The State Board failed to substantively equalize. The fact that they did it procedurally correctly is irrelevant. The order adopting the ratios was pre-drafted before that meeting of the Board of Equalization. When they had that meeting, it was already cooked. It was a done deal. There was no analysis. There was no determination. The word determination implies some level of investigation, some active analysis, reviewing something, but the State Board didn't review anything. They rubber-stamped a 100% ratio. Now, the division's duty to do a study is at least every 2 years. It's not only every 2 years. The Board of Equalization can order them to perform studies more often, and the board never directed them not to do one for 2017. In the absence of some instruction from the board, the Division of Property Assessments has a statutory duty to do one every other year. Not a statistical analysis, not whatever it is, but a sales ratio study. There is no evidence of an analysis. We requested all of that information. Anything that the division had done, we requested it. Nothing was submitted to us. There is nothing in the record that would indicate they looked at anything. The arbitrary and capricious decision wasn't made at the meeting. The arbitrary and capricious decision was made at the administrative judge's level. The State Board of Equalization was given our sales ratio study at the earliest possible time. It was submitted on June 15th, well before the State Board's own deadline for setting ratios of July 1st. So I'd like to read a few things out of the administrative judge's decision that I find especially egregious. The administrative judge said, and I quote, "It defies logic to expect the State Board to alter the ratio when the division is not required to produce a study." No, it doesn't. It does not defy logic. The State Board's duty to equalize doesn't vanish. The administrative judge said, "The petitioners argue that the language in TCA 67.5-1606A requires the State Board to annually determine the overall ratio for each county." Yes, we do. That's what the statute says. He says, they reason that because Dr. Sunderman's study proves the ratio for tax year 2018 is not 100%, it must be adopted. First of all, he's admitting that we proved that the ratio is not 100%. Second of all, yes, we do reason that it must be adopted because it proved the ratio. He weighed the evidence. He found it was flawless evidence. They cannot turn a blind eye to that now. Thank you for your time.
All right, thank you, Mr. Raines and Mr. Longnecker, for your arguments. We'll take this matter under advisement. We're going to take a very, very short recess because we have to swap out